We're live.
All right, good afternoon, everyone. Tuesday, May 13th, 1 p.m., 1:05. We are continuing to take testimony on S59, the open meeting law bill we've been working on for a couple of weeks. And we have representatives from the town of Fairhaven joining us now, and we'll have someone from Alburgh a little bit later joining us via Zoom. And we're continuing to hear from municipal folks about disturbance issues. And considering we've heard from a multitude of municipalities now, we're going to keep taking a look at some language that we discussed and kind of, I don't want to say honed in, but at least kind of took a look at what we thought was worth noodling on. So after we hear from the municipalities, if time allows, I'd like to discuss what words on the page can potentially look like. Sound like a plan?
Yes.
All right, cool. All right, gentlemen. Yeah, if you could please join us and we'll introduce ourselves. And
I'm in a time, it's time to.
And
Panic that this is not an epistle, and I'm not gonna sleep. I just need some notes to help me keep to the succinct points.
I appreciate that, sir.
Want to start with us introducing ourselves a little bit. My name's Glenn Travers. I'm the chair of the Fairhaven Select Board, newly appointed chair in March. So I have a vast experience in 2 months. It feels like it's been 2 years. So
I'm Joe Gunter. I'm the town manager of Fairhaven. I've been there about 8 years.
Sadie.
Joe Gunter.
And I guess just for us, we'll do some introductions. We don't, sometimes we do, sometimes we don't, but you folks are new with us. Representative Matt Firong, I represent Northwest Addison County, chair of the committee.
Hi, Representative Lucy Boyan. I represent 103, which is New Richmond, Mountville.
This all Dorset, I represent Dorset, Danby, Mount Tabor, Landgrove, and Peru.
Michael Morgan, Grand Isle Chittenden District, which is the entire county of Grand Isle. So Alburgh, North Hero, Alamont, Grand Isle, South Hero, and then the western corner of Milton.
Bill Coffin, and I represent Cavendish, Weathersfield, and Baltimore.
Mayor Captain Stoneborough.
You're a part of South Burlington.
Hi, I'm Shay Waters Evans from Charlotte and Heidelberg.
what I thought I'd do is just, I did not knowing exactly what you were looking for. I knew we were going for under S59, 312 right to the 10 meetings, and very specifically disruptions in meetings. That's what I'd like to talk to for a minute and share some of our experience with that. So the current state for the Fairhaven Select Board is that we have, and when I look, I see Paul Killington, we're not unique in being a board that from time to time you get that small percentage that come in to perform at meetings, and they're very disruptive in how you could getting the business of the town done. But in ours specifically, it's individuals that come to every meeting. It's every 2 weeks, usually bringing the same thing up at each time, making comments without being recognized by the chair. Sometimes it feels like they're performing for PEG TV. Now that we're, the requirement of everything to be taped, and if it's, there seems to be, it used to be coming in with their phones and filming themselves so that right after the meeting, they could get to Facebook or whatever to give their spin of what's going on. The bigger thing that I see with these people that are disrupting meetings is they come in with the sole intent to try to intimidate the town manager or police department and the board. Their intimidation is in the form of making false statements, come in with their own juried up paperwork and try to serve members of the board like they were part and parcel. We're working for the judicial system. Constantly second guessing and looking for that fatal flaw to every piece of minutes decision. Frivolous claims abound all the time. I won't bore you with the number that we're still, and there's some I can't talk about because we're still litigating, but it seems to be one right after another. Usually, most of the times when they're disrupting, they finish with their threat of suing. And most of the time, they're jumping up and down and beating my First Amendment rights for freedom of speech. What we've taken, and I've been on the board now for 7 years, we've taken an approach of sitting back and see if they'll run out of gas in the air out of them. I can tell you that 7 years later, they seem to be just growing in momentum, and how brazen, how when you try to call the meeting to order, they'll just ignore, talk over, and continue doing what they were doing. I'm not proud of the fact that the last two meetings, select board meetings, I had to recess the meeting in order to have the person disrupted removed. I'd like to tell you it was the same person. It wasn't. We seem to be in Fairhaven. We have about three, occasionally four, but three that they made it their goal in life to see if they could be a thorn in the side of the municipality and be the different information source. So just wanted to briefly tell you that's what we're living with. Actions that we take. I hate people who come with a problem and they don't have a potential solution. I can tell you that what we've done for ourselves, we've gone in, cleaned up our select board procedures and rules, remind everybody over and over again the few major items that we keep pushing, and we're a meeting of a body that's of the select board that conducts select board business in public. It's not a public meeting for them to air every grievance in the world. We used to have public comments up in the beginning of the meeting. It's great if you want a 3-hour meeting because they'll burn a half hour to an hour of every meeting and then get up and leave. The disruptors will. So what we've done is we've moved from 5 minutes for public comment, we put it to 2 minutes for public comment, and we put it at the end of our agenda so that we can at least get through the business of the town before we go into the next phase. Other thing that's concerning, at least about 2 years ago, the threats became more and more personal to individuals. We now have police at every select board meeting. It's a sad state of affairs when select boards have to have police to ensure the safety of the individuals that are in the room. That's what we've done for ourselves. And I come back to, what do we need from you? I'm going to sound very general because I'll be honest, I don't know exactly what it is you can do. But I put it in the framework of more effective tools in S59 to deal with this disruptive behavior. I really want to thank you for the opportunity to come and talk to you because it's spot on for what we're living every day. What's he talking about? The other item I put there was the piece on First Amendment rights and making it clear that it's not a license to harass, intimidate, or litigate against municipalities, as it seems like some have taken. Number 3, just help municipalities defend ourselves from the costly, frivolous lawsuits. I don't even want to begin to tally up, and Joe could probably do a better job of what it's cost us in frivolous lawsuits over and over again. It seems like even when you have disbarred attorneys that are told they no longer can do pro se defense without an attorney, they still find a way of weaseling around it. And I'm sorry I'm using that term, but they do with, I'm a legal friend, I'm not an attorney, but here's everything just like an attorney would put together. Well, it's great, but when these people have no means of which we can go back and recoup our legal fees or court costs and everything else, it's a pretty good expense for everybody. The fourth item is the security concerns. I've watched, and it's not just our select board meeting, I see it in school board meetings as well, other meetings, the number of people who used to come and sit and talk about what's going on in town. They are intimidated and will not even come to the meeting because of the people we have in there disrupting the meeting. The numbers are non-existent. The only ones who basically come are basically the disruptors. I'm only going to give you one last example that we had about 6 months ago where we as a board had one individual that was making threats on Facebook and online, and it got our attention enough that we actually got together. The police chief, Bill Humphreys, was going to be here. He's on vacation, doing the right thing, fishing with his son. So I'm good with that. But if he was here, he'd be telling you about how difficult it is for the police to enforce what we have. But also, we were so concerned about this individual. We were discussing, what do you do? What's the emergency egress? What's the window you leave open? Where's the vehicle with the keys in it so someone can drive to get away if we have someone come in here? Now, we've gone as far as talking to the district attorneys. We've had the state police investigate. Basically, when they come, because they make claims against our police department, we have to have the state police do the investigation. It basically came down to they need to make very specific physical threats before they can really do anything. Unfortunately, that leads to individuals that after the fact, you question yourself, all the signs were there and you did nothing. All right, so, and I'm not trying to throw all that on you, I'm just saying, that's who we're dealing with. So when I heard we had the opportunity to talk about this and putting something in S59 that would help us deal a little better with disruptive behavior, I thank you for the opportunity to talk to you.
Yeah, no, we'll let you go in case some of your statement may answer some of our questions.
I was gonna say there may be questions. Okay, so Glenn stole almost all of my thunder with that one. He hit all of the talking points I was gonna talk about. What I will offer up though, before I start my speech, is that if you have time, go to the Fairhaven Select Board meeting for April 15th. You'll see an extremely inebriated young man screaming at the camera, screaming at the officials, waving paperwork at us and the camera. So this is just an example of what we're experiencing down in Fairhaven. But to start though, I'm going to read a Facebook post from a young man. This young man, this is one of our disruptors. He says, I'm going to push the police chief to violate my First Amendment rights to speak at the next select board meeting. I cannot wait for him to tase me. Here's a young man that intentionally goes online, says I'm going to disrupt your meeting, and I hope you hurt me. Because it's my First Amendment right to disrupt your meeting, which we all know that's wrong. But it's tough to get that point across without actually, arresting a young man, which we're going to talk about when I'm done with my epistle. Okay, so you guys know me. I'm Joe Gunter. I'm the town manager in Fairhaven. And Glenn and I both have a select board meeting today, but this is an important topic, and that's why we drove all the way up to Montpelier, because it's a growing and deeply concerning trend affecting all of our local government. The intentional disruption of our public meetings and the accompanying rise in targeted threats against our public officials. Let me begin by stating something that we kind of take for granted. our local government, Glenn and I and you folks, we're the level of government that are closest to our people. My door is the first door you come to when you enter town hall. I'm the first door on the left. I like that because I can see my residents. I can address their concerns right away. We make decisions that affect everyday life, but increasingly our work is being impeded by individuals who attend public meetings, not to participate, but to provoke, disrupt, and in some case intimidate, just like Glenn said. We couldn't find somebody to run for select board. We had to kind of go fishing this year because nobody wants to put up with all the constant threats. These disruptions, though they may disagree, these disruptions are not rooted in disagreement. This isn't about policy. Because disagreement is welcome in Fairhaven and essential in our democracy. What we're seeing is behavior intended to derail our meetings, to dominate the floor through harassment and personal attacks, and to foster an environment so hostile to others, so hostile that others no longer feel safe participating. And that's not free speech. That's not a First Amendment right. That's harassment. And as Glenn said, it's performative aggression. This is all for PEG TV, so we can post it on Facebook, get some likes, and then maybe make some money on YouTube. We've all seen them. All the meetings are, again, more thunder stole. Public meetings are held in public. We're a body that holds our meetings in public, so that way the residents can see what actions are being taken. This is not a meeting of the public for the public. They have 2 minutes to interject. They're not there to run the meeting. Just as you wouldn't tolerate somebody walking into this chamber, constantly cussing, constantly interrupting your meeting, standing up inebriated, stopping me from talking, stopping the chair from talking, our select board shouldn't have to put up with that either, not just in Fairhaven, but across the state. When we allow this disruptive behavior to go unchecked, we're normalizing it, and we're seeing it across the state. We embolden it, and we drive good people out of public service, people who care deeply about their communities, but understandably who do not want to serve under this threat and abuse. We don't want people showing up at our doors yelling at us. We don't want to be posted on Facebook being called anti-Semitic, which is what's happening. As Glenn said, we're not 100% sure what you can do with the legislation. We're a country of laws. We used to be a country of laws. So we know there are guardrails on what you can and cannot do, but any help is appreciated. So I urge this body to consider stronger protections for public meetings for the people who serve in them. We need clear authority to remove disruptive individuals. We need accountability for those who do cross the line or from protest to menace. And we need to affirm collectively that civil discourse and the rule of order matter. So that's the little epistle. So I want to go back to the young man earlier who said, I'm going to go disrupt. Right? So as Glenn said, 2 meetings, the last meeting and the meeting before, Glenn gave him the gavel, we closed the meeting, and we asked people to leave, which is the appropriate step. This is allowed by our rules and the law. What did that get us? That got me a lawsuit. A Second Amendment lawsuit. So what we need are better protections. We can do certain things. We can put in place our board rules. We can follow VSA, but we're getting pummeled by this foolishness of Second Amendment law, Second Amendment rights, a right to gather in a public place. And, what's the odds of this going? What's the odds of this person winning this lawsuit? Probably not good, but we still have to defend it. And we still have to pay out the thousands and thousands of dollars in time and money it takes to defend that. We could use a little help, something clear that stops this foolishness from happening. Thank you.
Questions?
Yeah. So that it's very similar to what we've heard from other municipalities. Just to, I think I want to start with just a little bit more of a binary question. In the period of time that you've been dealing with this over the last couple of years, do you have any guesstimate estimate as to what the legal costs that you've encountered on this? We're just trying to get a sense from the various municipalities.
One group, it's over 6 years. And it's been a very long time. of multiple lawsuits, and I thought, Joe,
It's, so VLCT, as the insurer, they pick up a lot of legal costs. Some are on us, but our biggest cost is just the time and effort it takes to, fight this stuff back. But right now, I'm the highest paid employee in my town. And instead of doing the work of the people, I'm up here in Montpelier trying to get these people to stop harassing us. So every minute I'm here, every conversation I have about these people, it costs my taxpayers money. And that's not fair to them.
it would be safe to say, though, it's more than tens of thousands.
Upwards of,
It's
easily upwards of $1 million with insurance
It's-
claims and.
It's hundreds of thousands.
Yeah, and so I think like within that, with the context of that, like the insurance claims as well, because that is still a payout within this process and this nuisance. So that is a huge number. So 7 figures, like probably all in.
It's been a lot of years.
No, I understand that. And I think you've spoken to the longest time span of folks we've heard to yet, but that's like a 7 figures mind boggling.
I think it would help if you were saying, there's a difference between meeting disruption that a very passionate taxpayer comes in and I'm upset. They take and get a little hot and they calm down and everything's fine. And what we're talking about are the disruptors on steroids, doing their podcasts. I mean, if all you have to do, 3 of our biggest disruptors, Lillian, Jonathan Billowitz, Kevin Hoyt, just Google them up and see both of them very litigious. Well, one of them does their own podcast and everything, and I think they make their drama for their presentation.
I saw a hand from Rep Hooper and then Rep Pittsfield.
Not a question for these folks, question for you, Mr. Chair. My knowledge of where the criminal versus the civil versus the authority of the board to make a decision versus independent decision about police officer make a decision. Of how much council has the confidence to go into the differentiation, or if we need somebody from the AG's office, but it would certainly be nice to understand what capacity we can give town boards to effectively control their meetings without always having to have intervene and still not cross that First Amendment line.
Yeah, totally understand. And I think getting clarity on like where those those walls between the different mechanisms,
I mean, I could,
authority are.
as chair of a private board, I could throw somebody out of this building easily. Sounds like towns don't have that ability, and if that's also.
You mentioned Kevin Hoyt. Is that the same Kevin Hoyt that does all the disruption in Bennington as well?
Same one. Anya has been, he's been, and I'm talking about disruptors in the meeting. I'm not going to bore you with the emails and the hand gestures and the swearing as people are driving by with you, when you and your family are going down the street. Now, understand, you might say, well, geez, there's laws. We have gone with individuals, gone to our district attorney, got the okay to arrest, send them there, the judge throws it out. The disruptor feels emboldened even more and turns around and wants to sue the police for wrongful arrest. That's not something you control in S59, but I'm saying it all ties in. It's not just what you're seeing is the symptom in the meeting with the disruptor. It's a bigger problem. I don't expect to hear.
Could you describe to me a little bit more what you're referring to, like the social media content, or the YouTube presence and whatnot? So the disturbances that are occurring are then being spoken to and sort of highlighted and elevated?
Right after our select board meetings, there'll be one tonight, and my 3 major disruptors will be front and center again tonight. We'll be coming in, trying to push the buttons until they're asked to leave. I think that's their intent. But then by tomorrow on Facebook, they'll put these little pictures together. I've got to, I don't go on Facebook, but my wife, it bothers her a little bit. And she'll come back and say, here's one where he's swearing about you, got a picture that somehow has a way to get in to get the pictures from family snapshots, and we'll take and put something together, and we'll have something like, okay, Chairman Travers is anti-Semitic and so and so. Right out of not quoting anything or whatever, but just in an effort to
Stir the pot.
keep things going. Mr. Hoyt, he Friday sent emails to the board, Joe, saying that he was going to be suing us and had something laid out without a docket number or anything. And basically said, and I hope you have a, being sarcastic, I hope you have a good weekend, knowing this is going to happen next week. First thing Monday morning, Mr. Hoyt spent all kinds of money to put packets together, registered mail, and have them all to everyone, the select board and Joe. Still no docket number and everything, but it's just a way of just continually poking. And I don't know what he hopes to accomplish, but I'm just trying to describe that that's when you get that. It goes back to what Joe said of trying to get people to raise their hand to do public service. It's not easy.
You just floated the term anti-Semitic for the second time. What is the context of that?
Don't know. It was
Just.
I'm being, there's a lot of vulgar language. If the chief of police was here, he'd be telling you about in Facebook pictures of him and his wife and all kinds of really sick stuff that you would think. But online, there is no control of online. I'm convinced of it. The penalty is maybe in a couple of days that you can't post and then you're right back, or you have a new name. And that's what this, one of our detractors kept getting kicked off Facebook because he was so far out of line, kept changing and going in as a different name.
Oh, like ghost accounts. Yeah. Yep.
But
Okay.
I'm not expecting, well, my whole thing I'm looking for here, we'll figure out ways to deal with that. It's really, would like to get the business of the town done and done in a timely manner. And not stepping on anyone's First Amendment rights or anything else, but these people like to litigate. And once you say you litigate, stop trying to hand paperwork out and everything, but let them talk to our attorneys and deal with. We've had, as much as our attorneys have gone to one individual who kept sending stuff to say, look, individuals, because that's the form of harassment they use. They have our attorneys give them a letter to say, look, everything comes to me. I'm the attorney. Stop. And finally, what this one individual did, but it took that to stop it. So.
Any other questions for these gentlemen? PowerPoint?
We heard from local folks that they were receiving a lot of public records requests. Is that also the case in?
The latest, it seems like, what's the flavor of the month? The flavor of the month is to do a records request and then say we violated the days and then start litigation. And what happens is if you throw enough on the wall, they hope something will stick. So they ask for stuff they know they can't have. But in there might be something that if you weed through it, they technically could have. And that seems to be, we're spending some time filtering that out.
Is the nature of what they're asking about, is it relevant to what the town is doing, or is it just?
in the case of the records request we're getting from Mr. Hoyt now, he's got this vendetta against a person we hired as a police officer who a few years ago, was an officer in Pollitt, and therefore his goal in life is getting fired from the Fairhaven Police Department. So he wants all personnel records and things he knows he can't have.
Any other hands? Rep Morgan.
Just real quick, Joe, right?
Yes, sir.
Yeah, you mentioned Second Amendment rights being violated. Did you mean first?
Yeah, I meant first. Yeah,
I was gonna say.
I misspoke.
Just, I didn't know if there was
I
a
said
nexus with second.
No.
It missed and didn't talk about I assume just want to clarify.
Yep. Thank you for saying that. I was going to say.
It's like,
Yeah, I kind of picked up on that too, but yeah, I'm glad we clarified.
Yeah.
Rep Huff.
Yeah, you mentioned a select board meeting you referenced for April 15th. And that's one of the meetings where the public comments were at the end, to disrupt the end, or was all through it?
He chimed, the one gentleman chimes in regularly. But this particular time, it was time for his 2 minutes and he stood up and tried to hand out documents and yelled at the camera and yeah, so
Okay.
I guess it was during his 2 minutes, but
All right.
still can't act like that.
I was just wondering which part of that.
Oh, yeah, it was towards the back.
And the disruptors are very good at coming back, and like with the recent litigation, it's, the allegations are that we're using the bully pulpit and we're intimidating them. And I mean, the great thing is it's all on film to be the judge of what's going on in the meeting. It's crazy.
The reason I asked for consideration of more information was we're the ultimate public meeting.
Mm-hmm.
We get disrupted, speaker bangs the gavel a couple times and Sergeant Arms takes people away, and I'm not sure why that doesn't filter down to municipal levels.
That is a good question for council about how like they're structured differently.
So
Perhaps.
it 100% does filter down. The chair did give him the gavel the last 2 meetings, asked him to leave. But again, that got me a lawsuit. I understand. It's like,
Yeah.
so we're doing what we can do on our side, but at the same time, we need a little bit of support and backstop on that. Or maybe something a bit more clear in the law. Because it's one thing to say you're disturbing the peace in a meeting, but what we've received is, well, it's in public and we have a right to speak. So you don't, is what it boils down to.
I mean, tonight we plan on taking one more step with our rules. I believe it's 7 pages of rules just to have a select board meeting. That's what we've gotten to. And there's one of them that we're looking to add tonight. Probably will get challenged in court on it. We want to have public comment open to Fairhaven residents only. Now, I know this when people will go, whoa, wait a minute. Mr. Hoyt, for example, I think he lives in Bennington now or somewhere here, and goes out of his way to come and disrupt a Fairhaven meeting because he has a personal vendetta against an officer from years ago. And we're looking to say, wait a minute, we have an agenda. Do you have any questions about the agenda items? Okay, that's why we put an agenda out. That's the full disclosure. That's the transparency that we want everyone to have. I don't know, as we're going.
Rep Hisnall, and then I got one more.
Question for legal counsel, but is there anything that says when you're having a public meeting that you have to open it up to the public? It does.
Definitely. I thought it was.
Because I'm just wondering if you couldn't just say that you can only talk about the items on the agenda and nothing else, or is that taking a different speech?
That's literally what our rules say, and that's what BLCT recommended. You speak to the agenda.
Speak to the
If you
agenda.
don't, you're out of order.
If you don't, you're out of order. Yeah, right.
Aren't you required to have a public forum though in there? Which opens.
The public comment.
We put in item 6 that said toward the end of the meeting, there may be 2 minutes afforded. There may be 2 minutes afforded to open public comment. It was our way to deal with I'd love for you up here to change it, so we don't have to have the people from outside who don't have a dog in the fight, but are just there to disrupt. But
Because I'm also a selectman in my town of Milton, and we have it set, public forum is like up front, we do the pledge. Do a quick review of the agenda from the manager and the board's perspective of any changes, deletions. And then we go into public forum, but the chair announces up front anything that anybody from the public that's there has 5 minutes max to speak to an item that is not on the agenda. So we crafted our rule set with, I'm assuming as you're doing with your town attorney, I would imagine you're involving he or she in that process. And
Yeah.
so I think there's some ways you might be able to ratchet it down some maybe, but then that would give you some teeth to go. I say it would give you some teeth, I think, to go to in this case, your law enforcement folks and go, hey, time to have so-and-so removed because they're, we gave them their 5. I can see, all right, they slipped to 6. Okay, but then at some point you got to go, all right, enough. And especially if you give them a warning, I'm just trying to throw some ideas out there.
oh, I think that's sure.
Not saying we have it all right, but
Rep Hassel, and then I have one question. I want to be mindful of the gentleman from Alburgh.
I'm also a town clerk in Dorset, and so I understand exactly what you're saying. And I've been trying to advocate, excuse me, for like 3 times you're out. You're in timeout for 6 months or something, you can't come back, you can't contact us, you're out of here. So I understand and I hear it, and it just amazes me that I Googled him, Kevin Boyd, and lawsuit with Fairhaven comes up and harassment in Bennington, and yeah, he's a lot, he makes some frowns for sure.
My question is for you, Joe. In a 40-hour work week, let's just say you work the baseline 40. How many hours do you think on average you're committing to this type of focus and an issue as opposed to all of the other things that you have to manage within your role?
This does tear through a lot of time. Out of 40 hours a week, I would say anywhere between 5 and 10 hours a week. So upwards of a quarter, 25% of my time is spent. That's a day. So 20% is 20% of my time, about a whole day a week, give or take, is just spent on whether it's conversations with the police or conversations with the select board or doing something like this or gathering information for the frivolous requests. It's easily a day a week.
Okay. And how many other folks do you have working with? Are you?
The office is, I have 3 support staff and then a rec director. Okay, so I got 4 of us in the office.
So with this is probably more focused as the sports staff. Are they seeing like an equal amount of time spent on these issues, or do they wind up having to focus more on the?
So if there was this big push last year, 2 years ago about all the malfeasance in our budget, as though there was money being stolen. So that was a big lift for our accountant at the time, but that kind of petered out. So at that time, it was a lot for her. At one point, it was several hundred documents that they wanted. Several hundred, yeah. So we actually had to have the lawyer put a stop to that, but not as much as me, but quite a bit.
Understood. All right. Well, thank you very much. And if you don't mind hanging out in case we have some other follow-up questions for you after we speak to Mr. Hogenberg.
Okay, you're unmuted, Jim.
Okay.
How you doing, Mr. Hogenberg?
Yes, I have a statement here to read. Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to testify today regarding a troubling and potentially dangerous situation facing the Alburgh Select Board. I understand that the bill before you today, Act 59, would contain several amendments to Vermont's current open meeting laws. As my testimony will illustrate, there is a need to amend the current statute to ensure the proper balance between public transparency and the ability for local officials like myself to do our work. First thing, I'd like to provide the committee with some background on an issue currently facing our board. I know that we are not the only municipality, obviously, with similar stories. In December 2023, two individuals from a neighboring town were placed on the Alburgh Select Board agenda. After requesting time to address the board about a complaint regarding the county sheriff, during the board's first interaction with them, these individuals were rude and unreasonably combative. In January 2024, these two individuals attended a select board meeting demanding to discuss their complaint. Board members informed them that this meeting was a special meeting for budget planning and that they were welcome to listen in, but had to stop interrupting board members and demanding answers to topics not on the agenda. Eventually, they departed that meeting. At the next regular board meeting in January 2024, the two individuals returned. One of them was video recording the board meeting with their phone, invading the personal space of board members to record them uncomfortably close. He interrupted the board chair with continuous questions and began raising his voice about how his rights were being violated. The board chair attempted to maintain order by referring to the meeting rules and procedures, but efforts were unsuccessful. Eventually, the town administrator and one select board member escorted them out of the meeting room. The two individuals argued and yelled at the town administrator and selectmen until eventually agreeing to leave. Members of the board, members of the public expressed they were frightened by their harassment and attempts at intimidation. The board did not hear from them again for over a year. Recently, one of these individuals began engaging the town clerk and town administrator with official record requests, personally centered on the former chair of the select board, who now serves as the town administrator. The tone of these requests has been rude, threatening, unprofessional, and accusatory. This email correspondence has been above and beyond a reasonable amount. Within the past 11 days, our town clerk has received over 34 emails requesting various records. This presents an inordinate burden on our limited town office staff. The town office staff is overwhelmed and stated these requests are interfering with normal duties. The individual has stated he will be appearing at an upcoming select board meeting, and the board is struggling with how to ensure the safety of its members, other town officials, and the public while adhering to the state statutes. We are engaged with our attorney, but there is little we can do other than answer the request and brace for another chaotic and potentially dangerous meeting until legal changes are made. We recognize the importance of transparency and accountability in local government. However, there is a fine line between being a gadfly, which supports the public interest by promoting transparent practices, and being a burden to public resources for personal vindication. These interactions are wholly outside of the public good and take valuable time, resources, and energy away from pressing matters that our constituents need us to focus on. And thank you again for this opportunity to read you this and testify. I look forward to your questions.
No, thank you very much, Jim. First, I'm sorry this is going on in your area of the state for the board and for the staff and the municipal employees. First thing, the statement that you read to us, could you or someone email that to us so we could have it on record?
Yes.
Thank you. And how much staff does that office have?
We have the board, select board, we have our town administrator, we have our town clerk, and we have an assistant town clerk.
Okay, so the board, about three employees?
Yeah.
So I'm gonna ask kind of the same questions I was asking before. Do you folks have an idea of what the legal cost burden has been for the municipality while trying to navigate this stuff?
I don't have a figure on that. Josie, do you?
This is Josie Henry, the town administrator. Is it okay if I chime in?
Oh, please do. Hi, how are you?
Hi, great. How are you?
Not bad, not bad.
So as far as legal costs, we have tried to avoid involving the attorney until we really needed to. So we're just getting started on this round. The last time things happened in January of 24, we didn't get the attorney involved. But I can say, because I'm also a county official, that this same individual has been engaging in these techniques at the county level, and we've spent thousands of dollars at the county level to date dealing with the legal issues.
Right. And then I guess sort of how many staff hours do you think this is occupying on a week over week basis?
I would say it's about the same as the other gentleman spoke, 5 to 10 hours a week.
Yeah.
Okay. And the disturbances at the county level, so at the county courthouse, I assume?
Yes, the courthouse. I'm assistant judge, so county administrator, and also sit as a site judge.
Oh, okay. Well, thank you for doing all those. So is it the same sort of engagement that with the individual is just the disruptive nature of records requests? Is it paralleling at the county level to what you're experiencing at the municipal level, or is the contact not the same?
The records requests have been voluminous at the county level and culminated with a federal suit being filed against Sheriff Ray Allen, myself, and the county clerk, Susan Bohannon. So we're not sure at this point where that litigation will go. And so those legal costs I mentioned earlier could end up being a lot higher. But once it did start in the same way that this one is, with many records requests and then accusing us of, as someone else mentioned from their town, not following the days required or responding fast enough, and then filing a lawsuit.
And then the federal situation, what is, you said a lawsuit at the federal level as well?
Yeah, we haven't been served, as in myself personally or the county clerk, but I believe Ray Allen was our sheriff, and we're waiting now to hear next steps on that.
Brett Morgan?
Hey, Josie. Hi, Jim. Thanks for coming in and testifying. Have you all ever had to have Ray Allen actually come up and physically remove anybody? Have you ever requested that? Has that ever had to been done, or state police, or any law enforcement involvement directly?
No, we haven't actually had to have a sheriff here. We have, spoken to Ray about possibly having sheriffs in the area in case they're needed.
Mm-hmm. Okay.
And we did contemplate having him at the January 2024 meeting, but the issue at that time was somewhat tied to the sheriff, and it was a complaint about the sheriff, where again, as another person testified earlier, we felt they were disrupting us to get us to call them so they could file, or get in some sort of altercation with the sheriff's department. So I think had that not been going on, we would have had him at that meeting.
Yes.
Okay. All right. Thank you.
I'm just trying to think if I have anything left to ask.
Commonality.
Yeah, no, it's very similar.
Same stories are resonating throughout.
I guess my last question for you folks is, what do you feel would be helpful to see as a legislative possibility to help mitigate the issues that you folks are having?
I've thought through this and I'm very aware of First Amendment rights, and it's a really difficult dilemma. But if we were able to say someone who violated the procedures of our own board on multiple occasions and could then mandate they attend virtually, not in person, I thought that might be a way to get at this. I don't know what your thoughts are on that.
That would work.
Okay. No, thank you for that. I appreciate it. And if you don't mind sticking around for a second, just in case we have a couple of questions, I kind of want to see if the committee had any questions for council right now. And then I also wanted to entertain just being aware of the calendar and our desire to get this bill dialed in, hopefully by the end of the week, to vote out what people's thoughts were on how to approach this. Rep Pango, and then Waters, and then Stone.
I think it was fairly succinctly said by Josie just now that if there could be something to say that you either follow the rules that are set by this legislative body, which in statute is the chair of the legislative body who can set those ground rules. If you don't comply with them, then you have lost your privilege to come in person, but you are welcome to attend online. The select board or the other legislative body is being disrupted, and make the determination how long period of time that would be.
That sum up your thoughts, Josie?
It does, thank you.
Yes.
Rep Waters Evans, then Stone, then Nugent.
So I'm just confused about, I looked up that it's 13 BSA 1026 and it's disorderly conduct. That's the conduct, that's the crime, right? And it says a person is guilty of disorderly conduct if he or she with intent to cause public inconvenience or annoyance or recklessly creates a risk thereof. And then it has like a bunch of things like unreasonable noise in a public place using abusive or obscene language. Also literally says without lawful authority disturbs any lawful assembly or meeting of persons. So it seems like that is already a law. So I know that it's a problem for everybody, and I sympathize and I empathize and I understand. I understand that it's disruptive and it's violating, constitutional rights of the people who are trying to assemble. The part I don't understand is if we already have a law for this and there are already police there, do they not know that they can charge people with disorderly conduct? It gives even the penalty here of like what you can do. So like, I don't I guess I don't understand where the disconnect is, why we need to make another law that is essentially replicating this law that we already. I know I've asked this 100 times, but I'm just not getting it.
It's good to be back.
Hi, Tucker.
Who's this name? Good afternoon, Tucker Anderson, Legislative Counsel. So to jump right into Representative Waters Evans' question, you are correct, and we did cover it last time, and maybe even when I did the walkthrough of Representative Harrison's bill, that in 13 VSA Section 1026 in subdivision A4, you have a basis for an arrest when an individual without lawful authority disturbs any lawful assembly or meeting of persons. However, we discussed that there is a decision from the Supreme Court of Vermont, State v. Colby, where they analyzed instances where this particular subdivision has been applied. And by the court's own terms, they were saving this subdivision from being deemed unconstitutional by providing some standards for when it could be applied. And even in that context, we weren't dealing with a meeting of a public body or any affiliation with a unit of government. We were dealing with a lawful assembly at a private academy. And still, even there were concerns around the violation of individuals' First Amendment rights and the possibility that this disorderly conduct statute would be deemed unconstitutional because of subdivision 4. I flagged last time that when we're dealing with public bodies, meetings of public bodies, it's likely that the standard gets raised even higher. What Representative Harrison's language did was, without touching that subdivision 4 and the existing authority, added a new subdivision that borrowed the terms used in State v. Colby so that you have a baseline standard for the law enforcement officer and then for the prosecuting attorney, and applies it to meetings of public bodies. So substantial impairment of the effective conduct of a meeting of a public body. The legislative intent in Representative Harrison's bill, that first page, very long paragraph, articulates the General Assembly's intention for the standards and how this would be applied. It talks about instances when the meeting has to be stopped for a substantial duration. Then you have some sort of metric that can be applied. All right, the select board meeting was stopped for 35 minutes while the sheriff was called to come remove this person from the meeting. That could be the basis for a disorderly conduct citation.
So my follow-up question would be, why would this fall under, and this may not be a question for you, why would this fall under GovOps jurisdiction? Is it because it has to do with a public meeting? Because it seems like it would be more of a judiciary issue, because it seems like the crimes and the criminal procedures, the stuff that they deal with, not our committee.
Can I jump in? Because that was my question as well, was how is this in the scope of government operations and not judiciary? Because I don't know if rewriting open meeting law is really going to get into the consequences of, as the judiciary does consequences. We don't.
Right, like the sheriff can remove you.
Yes, they deal with the consequence.
We're working on Rep. Harrison's bill, which was assigned here. So obviously, jurisdictionally speaking, because it's a lot of what we're discussing is within the structure.
But we've had bills relieved from committees before, after it's been taken up for discussion numerous times, because they found that the actual scope of the bill, once they discuss it, is not within the jurisdiction of the committee it was assigned to. So it wouldn't be like an unprecedented thing.
I was actually leading into that.
For that
Yeah,
to
I was
occur.
actually leading into affirmative right there. Did I see a hand up a while ago for propagation?
Yeah, I was just gonna, I think that we have to set up the structure for which the consequences can be applied, so I think that's why.
We have, the open meeting law is the law, and then we're discussing the consequences of when that is not adhered to. So I'm just very confused at why we're circling the drain over here with trying to discuss consequences without judiciary in here.
Council.
The open meeting law is firmly within the jurisdiction of this committee. Representative Harrison's bill amends the open meeting law and then provides a criminal penalty for violation of the reasonable rules that would be adopted by a legislative body under the open meeting law. And you can have overlapping jurisdiction between committees. This committee worked on the sports betting bill last biennium. It had a whole series of criminal penalties that was also reviewed by judiciary, but the bill itself was within the GovOps jurisdiction.
Thank you. Thank
Just a clarifying question, Tucker. Did I hear you say that by using the language in State v. Colby and adding the terminology of a public body, that would put it into this ballpark, this open meeting law ballpark? If that were the language that we would contemplate using to apply the already existing statute to, which has been tested or challenged, to public meetings.
I'm going to step back and Representative Harrison's bill and the language that is proposed to be added to Title 13. The intent is to provide some clarity for both the public bodies, law enforcement officers, and the prosecuting entities to understand how this could be enforced at the local level. Right now, public bodies are relying on the authority of the chairperson to adopt rules governing the public participation in meetings under 1 VSA 312H. Then if those are violated and let's say the meeting is disrupted substantially, they're relying on the current language in Title 13 and the Supreme Court cases that have interpreted it in order to have a citation for disorderly conduct. And in most instances that I'm aware of, the prosecuting entities are typically not willing to proceed with a case because of some of the uncertainty around the tension of, for example, First Amendment rights and the legal basis to actually cite the individual at the local level. And we've talked about some local incidents where cases have been dismissed or potentially not even brought by the state's attorney related to disorderly conduct in public meetings. So the intent is to take the standard that the Supreme Court has given us, add it to the statute, and expressly tie it to meetings of public bodies. Who knows if that would be challenged and deemed unconstitutional in the future, but at least we would be grounding the open meeting law and the disorderly conduct statute in the guidance that we have right now from the courts.
And Rep. Hooper and then Waters.
What? I was gonna say, we're not talking about the open meeting law in the First Amendment sort of context as much as we're talking about the person that yells fire. And your previous description focuses on that. The fire thing is the thing we want to get to. However we do it. However delicately we have to step on the ice.
Rep. Waters Evans.
You can skip me, thank you.
Rep. Nugent.
I was just gonna restate what I think I heard you say, which is that the municipalities are looking for some kind of clarification, affirmation, like we do in a lot of other laws, that they can indeed set rules and enforce them in their meetings so that they can be a little bit covered from these frivolous lawsuits.
And that the law enforcement officers would have similar backing where they could point to the statute for the citation when they remove an individual. And we discussed, especially in the context of State v. Colby, you could have the removal of an individual from an open meeting without having a criminal citation. Totally possible. In fact, if the individual stops disrupting the meeting and, voluntarily leaves the meeting with the law enforcement officers, it's not likely that they would be charged with anything at all, because it wouldn't rise to that level of the substantial disruption or the repeated attempts to disrupt the meeting, which are kind of the two standards that the Supreme Court has given us for the enforcement of disorderly conduct that disrupt lawful assemblies.
Is that a question, Sue?
Yes.
Okay, please.
So what was it that Senator, or that Representative Harrison had in it that the Senate struck out?
Nothing.
Nothing.
This is a brand new
Separate bill.
consideration, separate bill.
Separate.
It was H 145 that he brought us earlier in the session that were,
So they just basically rewrote it as S-59.
no.
No, S 59 is the Senate's open meeting law bill. We are now taking conversation within Rep. Harrison's H 155 and considering it for inclusion in the open meeting law bill.
So then my next question would be, in order to do that, we'd have to have another subchapter of it, correct? If we were to add something to
A new section, yeah, or yeah. The cross-reference.
or the cross-reference to
Yeah.
that, to the disruption.
You can pluck things from other bills and embed them in.
Yeah, so what we are doing right now is considering an inclusion
Of
in the bill.
That's-
Yes, a component of, not the bill itself. His bill had a lot more in it and a lot more, many more moving parts. So we were kind of honing in on one piece of language from it. And the goal was to sort of, I see your hand, was to see if we could do something that would aid the municipalities right now and then have a bigger conversation that would happen when we come back in January. And that was that line we were talking about. Substantially impairs the effective conduct of a meeting of a public body. Was that a pull from Colby? Yes. So we were looking at that structure within the bill and within the case that council is referencing.
So the part that Matt or Chair Byron just read was we would be adding that. That was one thing that was suggested in Rep. Harrison's bill, H 145, that it's added to the disorderly conduct section of it. He had a bunch of other things, like a lot of other stuff. But I think that part on its own with me, but anything else, I feel like I'm a little uncertain about still. So that if we wanted to do something with this open meeting law with S-59 right now, for myself, the only thing I would really feel comfortable adding from all of his things is just that one line, that extra thing in the disorderly conduct. If that's something that the Supreme Court of Vermont kind of already laid a path toward anyway. Because it doesn't seem like it's opening the door for any other ways to impede like public participation or undo or diminish the open meeting law stuff that we have going right now.
I've kind of lost track of which language you're referring to, Rep. Waters Evans, so if you could.
145.
Yeah, so
Yeah,
it's
in
page-
145.
page 4, line
Thanks.
5.
And that was when we started our
Yeah.
meeting today. This was the component that I was referencing. So
Yeah.
I think we kind of naturally cascaded into this
Sorry,
portion.
I missed the beginning of the
Nope,
meeting.
that's all right. That's all right.
Thank you.
We're all on the
Okay.
same page.
Yep,
And so that's the piece that I wanted to reference as the language that I wanted to consider moving on.
and I think we have spoken about that as a committee, that we were not going to look to roll this bill into.
Not the bill, but the
OML.
line.
Yeah.
Yes. Certainly not the bill.
Yeah.
Yes. So, and I don't know if any of our friends from our municipalities here are familiar with that language or that line, but I'd be interested in having them kind of like marinate on that and take a look at it and maybe speak to some of your people and see if it was something that would help you, because I don't want to also do anything that is unnecessary, superfluous, or feckless. So. Rep Hisnell, I see your name.
Yeah, I just think that we've heard so much testimony from different towns. Now we're up to like 4 or 5 towns now that having the same problems. And I'm sure there are more that just have caught on to what we're doing here to give more testimony, but I think we owe it to them and to all municipalities in Vermont to have something in this bill that refers to disruptions.
I, as an individual member of this committee, agree with you. All right, team. Do we want to talk about this language a little bit? I mean, we do have Tucker here for the next order of business, but I think this is more of a front burner conversation while we're heads are in the game. Rep Waters Evans?
I'm comfortable with that one section, that page 4 of 145. Which, what's gone? It's just,
the effective conduct of a meeting of a public body.
yes. That seems fine to add that. And I think that we could.
Yes.
Yeah, I think anything, well, the reason I was talking about judiciary is just like I still think some of the things that we have heard, like reflecting back on like the 2 town employees that testified last week about the person coming to their office when there wasn't a public meeting going on and then being afraid that he was using threatening language in the town about like, I think that is like more of a judiciary conversation, I will say. And I
don't think that-
learned some stuff that I feel like doesn't fall under the scope of our committee, but warrants conversation elsewhere. But I would agree with Representative Waters Evans, that line seems like a way to address it without getting too in the weeds and some of the other stuff we heard, which I don't feel like is appropriate for our committee to be on.
Any other thoughts on that?
Yeah, I think they're definitely kind of tied together, but I think they're two issues that we need, there's a bill separate from outside of open meeting law, just disruptive and protection of our municipal workers.
Yes.
That needs to come from judiciary, as we are seeing that, and that's sort of what I brought up about the state of Maine. And the protection of municipal workers, so that you can't just barge into the town, to any municipal office and start making accusations and threatening people and also through this side, and then the open meeting law that you cannot disrupt the meetings. I think they're the 2 issues, but judicial needs to handle the one to protect the municipal workers.
Yes, Rep Hango.
So spoken as succinctly as that, that's a great idea for a bill to introduce for next session that probably would get at least some oversight by judiciary, as well as probably oversight by us. But when we have a specific idea like that it really is different, I think, from what we were considering putting in this bill, in the open meeting law bill. It's like 2 separate issues. And I think a good way of getting attention for that is to submit a bill request for such a bill.
So what I said and Sandy said. Now you say.
Right, I just wasn't sure Rep. Pincinel knew the process of how to go about that. So just wanted to bring that up, that if that's something you're really passionate about, that's why we're here as representatives. Is to put our ideas into bill form and get them looked at.
I mean, honestly, I mean, like 145 could be a vehicle for that as well. So maybe we just take it up and I was talking about next session, but we could take it up and amend. All right. So, I'm just looking at this week's agenda. Yes. Where's it?
I just wanted to thank Tucker for explaining that to me for the 700th time. I got it now. It's wrote in my notebook. Now I understand it. Good.
Even if we have to come back to it, I'll be so happy to run through it again. And I forgot to send you all a copy of State v. Colby, but I just downloaded the PDF, so I'll circulate that shortly.
It just wasn't sinking in, but now it's here. It's here. We're good.
It took me
Thank
3
you.
or 4 cracks on O'Brien to get powers to the house, really. But now I can almost recite it. All right, so looking, yes, we have this.
One more question. then.
Please.
So this disorderly conduct part of the H 145 bill, the A, section 3A, that whole sentence with A thereof. That's what you're interested in putting that whole section into this bill. A person is guilty of disorderly conduct if the person with intent to cause public inconvenience or annoyance or recklessly creates a risk thereof without lawful authority disturbs any lawful assembly or meeting of persons, vehicular or pedestrian traffic, or substantially impairs the effective conduct of a meeting of a public body. Or you only want to put in just the number 5.
Everything that's not underlined is already existing laws.
Yes, we just.
So there's,
The underlined stuff is
Yeah, but-
the new.
But it's
in
not,
5, they were adding an or, and that's just like a little bit more like housekeeping on the language, I would believe.
Yes,
Thank you, council.
it will no longer be the last item in the list. So the conjunction comes after it now.
And then on the A, it's the change from the he or she to the person.
right,
And the or is removed on 4.
Everything is.
Junction of the conjunction.
Yeah, to subdivision 6.
okay, I got you now. This is already open meeting law. He just added line 6. We're gonna put it into this one.
Right. That is, and so that's like the substantive change in addition would be 6, but
First time here.
you gotta strike an or and add an or. Thereby linking
You're doing great.
the conjunction to the junction as a function.
Gotcha.
So, we're taking this up again in 48 hours, roughly 48 hours, like 18 at this point. No, sorry, my math's wrong. Wednesday, Thursday, yes.
So have we agreed that that's something that we would like to add?
That's what I was about to ask.
Oh,
That's literally what I was doing.
sorry.
Yeah.
I thought you were just wrapping up and I was not.
Well, it's a step to it,
Okay, I will rewind.
as the ranking member said. Are people comfortable moving forward with this draft language for us to consider when we do discussion and possible vote at 10:30 a.m. on Thursday, May 15th?
Of just section 3. Or the.
Well, no, I want to wrap this bill up. Yeah.
Oh, no.
All of our
I'm talking
all
about
highlights.
145.
No.
That's
Okay.
59.
59.
I know, but
Yeah.
my question is,
No.
are we taking any of the language and incorporating it? Are we taking any of the language from 145 and incorporating it into our amendment to?
This line we're discussing.
Yes, just the bottom.
Just
That's what I was
that
asking.
one line. Yeah. Well, actually, these subsequent line with the conventions and such. But yes. I see a hand from the gallery. Mr. Gunter.
I'm sorry to interrupt.
No, please. I appreciate it.
What you work doing on this. This sounds like it's gonna really help us. I have a very litigious resident who will read that and say, this wasn't a substantive disruption. And then the next meeting will come and it will be a 4-minute disruption, and then next meeting, could we say, and I'm just tossing it out there, chronic disruption as well, because what we get is a repetitive, for 6 years, it's been an ongoing disruption. So, something to toss out there. I'd be remiss if I didn't say.
I really appreciate that input. Council, thoughts?
So walking us back to the last few times that we went through H 145 and the language, try to draw a line between criminal disruptions and all other disruptions where the public body might ask the individual to leave. So the rules of the public body could be adopted to be, in fact, quite narrow, have a limited amount of time with the consequence that the individual is removed if they violate the reasonable rules for public participation. What this Title 13 amendment is going to do is give teeth to a law enforcement officer that has been called to remove an individual who is substantially disrupting the meeting, to cite them with a criminal penalty here for disorderly conduct. So some of those less substantial disruptions could still lead to censor in the meeting or removal of the individual, but might not rise to the level of criminal conduct and the standards that have been given to us by the Supreme Court.
Rep. Hooper, Rep. Pisnell.
So to get to the point where the law enforcement officer comes in and charges, somebody has to
call the cops and stop the
somebody has to
individual.
give them probable cause to arrest, right? Other than saying he's been. So they're gonna be on the hook for.
They're going to be on the hook for adopting the rules. They're going to be on the hook for overseeing the meeting, which is the chair's responsibility anyway, and going to be responsible for making the call, for example, to stop the meeting during that time in order to have that individual removed. And some of the litigation and litigious practices have been brought up quite a bit. This is not going to stop that from happening. And I am not certain of many tools that a government agency would have to stymie the potential for litigation, even where you have all of the available regulatory levers to pull to have an orderly meeting. You still may have litigation that follows it. You might have frivolous litigation that follows it, and then it's the province of the courts to determine how to censor an individual who is bringing baseless suits.
In light of what Mr. Gunter just said, I'm just wondering if number 6 couldn't say substantially or chronically impairs the effective conduct of a meeting of a public body. Could we add that word?
You certainly could if we
That's a question for legal counsel.
I will take a look back at Colby. The language that is used when they're evaluating the standard and whether the threshold was crossed in that case is substantial impairment of a meeting, not repetitive conduct over a series of meetings. However, Colby did cite a whole string of Ninth Circuit cases, including In Re K, which was a Court of Appeals decision from California. And I can take a look through those cases and see if there's been another standard that we could borrow. It wouldn't be binding in our jurisdiction, but perhaps we have some sort of legal foothold for adding in chronic disruption.
Rep. Coffin, did I see a hand before?
Nope, well, you did, but my question got answered.
Okay. So to make sure we didn't skip over you. Rep. Hago.
So just as an alternative to that, because I had also penciled that in, Rep. Pincinel, but I'm thinking about this, if this is changing the statute to give law enforcement officers more of a grounding to be able to remove and charge somebody with a criminal offense, I think that you probably wouldn't be calling a law enforcement officer unless there was a one-time substantial blow up or the individual has done it repeatedly. So I think substantially in this case, if we're just talking about calling law enforcement, would suffice. And maybe from the gallery, they might understand that as well. What I will say is that this will probably not help the municipalities like mine who don't have ready access to law enforcement officers. So just throwing that out there. This is really for municipalities that are going to be able to call a law enforcement officer and have them arrive before the meeting adjourns.
I have Rep Hooper, and then we'll go back to Pisnell.
Is there any expectation of notice to the offender from the chair or?
Yeah.
That would take what form?
Typically, it would take the form of the chair pausing the meeting, telling the person that they've gone over their time, for example, or that they're going outside of the confines of the matters that were discussed during the meeting, which is one of the limitations that was brought up earlier. This isn't something we're discussing today. You need to confine your testimony to the matters before the public body. So that warning and notice goes out from the chair. You certainly could add it at the H 145. Nailed it. Did tee up quite a few components about the legislative body as a whole adopting the rules that would guide public participation. And the purpose of that was to provide notice to the public of what the guardrails of public participation are going to be for future meetings. Something that the committee has done in the past in similar areas is you've asked state agencies to provide guidance and model language to municipalities that could be easily adopted. It's not something, the other parts of Representative Harrison's bill aren't something that you've discussed today or that you've discussed substantially in the past, but that could be something that if you come back to it, you add is tasking a state agency with providing model rules that could be adopted by a legislative body, including how to provide notice during the meeting of a violation of the rules and the potential that the individual would be removed.
Yes, Rep Pisnell.
I think on page 145 on the second page, first sentence that starts on line 2, it goes, it just stating that members of the public should be able to attend meetings and engage in free interchange of ideas, but should not be permitted to obstruct the continuation of a meeting without regard to the explicit rules governing the meeting's conduct. That big there.
Yep.
That's the statement of intent from the General Assembly for Representative Harrison's bill.
And I'm looking for something that like the chair.
Sorry, I can't hear you, Bob.
And I'm looking for something that invokes that, like the chair saying, restrict.
Okay, so I believe where we are right now is council is going to take a look at adding the continuous was the
Chronic.
chronic. Okay, thank you.
Serial.
It's alphabetically like in the right vicinity. So taking this up again on Thursday, that I assume affords you the time to take a look into that.
Yes.
And then I believe this is the last component of this bill for consideration right now. Other than that, committee members seem to be fine with we took a lot of testimony on things, but we wound up not really doing much with it. So please be aware of the changes that have been made, because I would like to just really focus in on the inclusion of this piece and make sure that we are content with its mechanisms and functions. And I would still very, very, very much like to hold to the voting timeline of this on Thursday morning, just to be abundantly clear. Because we are looking at a tight calendar creeping up at the end of this week. Get things out with amendment in time for the Senate to consider. That sound good?
Mm-hmm.
All right, cool. I think that was really productive. Thank you again for your input, folks, and for you out there in Zoom land. Thank you so much. And we are gonna pick up work on the, Tucker, are you still clear to work on the?
Thank you.
Cool. So let's call a 5-minute timeout. Hey, well, let's come back at 2:45. We'll call it an 8-minute timeout.